We are joined via Zoom by our legal and transformation practitioner, Thabo Masombuka. Thabo, thank you so much for joining us this afternoon.
Good afternoon, Zolega. Good afternoon.
Now, Thabo, what should we make of the scenes that we saw playing out in court yesterday? I mean, a scene that's been described as unprofessional and a form of intimidation by the South African Police Service towards the defense attorney.
Well, 24 hours is such a long time, isn't it, for developments? Because if me and you had the discussion yesterday, we would have been attacked at the level and the mannerism in which the police handled the arrest of advocate in that Senzo Meyiwa case. Just under 24 hours later, we now know that the advocate had absconded from court appearance in at least 2 occasions and has tendered an explanation in the magistrate court early this morning, in which case he was granted 10,000 rand bail and given the benefit of the doubt to appear again on charges which seem to be unrelated to the matter at hand. So it's quite interesting. But to go back to your question, it is the mannerism that we must be concerned about. It is the posture. It is the granted display of arrogant authority that we saw. Because even if indeed the warrant of arrest against the advocate in the Senzo Meyiwa case was legitimate and valid, perhaps the mannerism in handling his apprehension was quite frankly unacceptable, to say the least, embarrassing, and out of posture.
And I'd like us to discuss what he's currently being charged with, but just going back to what you are saying and talking about just that whole mannerism. I mean, what does this arrest then, in terms of the manner in which he was arrested? Not read his rights, handcuffed in court, no explanation in terms of why he was being arrested. What does it mean for the actual Senzo Meyiwa trial? I mean, a trial that's not only high profile, but one that has been close to 8 years in the making. What are the implications?
The implications are quite dire, my sister, to say the least, because if you look at how that arrest was carried out, that arrest is carried out immediately after the advocate in his line of cross-examination has implied and suggested that there are major generals and senior police officials who tampered with evidence in the crime scene of the case of Senzo Meyiwa. Me and you know that this case has been protracted quite numerously and has taken all forms and shape without any probable and credible explanations given by the ministers, and I'm including particularly here even the previous Minister of Police. And if the public looks at this arrest and looks at and link it to the manner in which Adv Teffo has pursued his line of questioning, in essence suggesting to the first state witness that the reason why this case took long to resolve is because there were senior police generals, including an MEC of Safety and Security, who attended the crime scene prior the investigation officer who testified in court. Something that is quite an anomaly and unprecedented in what is called investigative SOP, standard operational procedure. So what Teffo was trying to get at and imply was that there is a probable version by the accused that they are being implicated falsely in a case where police have already buggered up this case. And then immediately you witness such a Hollywood type of arrest happening shortly after the court is being adjourned. The public has reasons to lose confidence in the police and to get and gather the narrative and impression that there is something to hide. But of course, 24 hours later, we now know that in fact there was a valid warrant of arrest. Whether or not the warrant of arrest is based on legitimate and credible criminal charges is something else, because if it's for trespassing, one wonders how can you as a practitioner, a legal practitioner, be charged with trespassing when you are attending to matters of your client? Because word says that Advocate Teffo was charged with trespassing for attending to matters related to his clients who are police officials who have been either suspended or dismissed unlawfully or unfairly. So he was attending that, challenging the status quo and challenging their dismissal. And in the process, he apparently made threats to expose and disclose some of the rot and corruption that was taking place in the police system. Me and you would recall that the Crime Intelligence Service, under the then Richard Mvuli, now convicted criminal, has been riddled with all sorts of abuse and mismanagement. So it is clear that there's more than what meets the eye here.
And Thabo, perhaps it is the theatrics, also the layers within this case and the speculation that has so many people confused. But let's talk about some of the serious utterances that Advocate Teffo made minutes after his arrest yesterday and again after his court case today. He says that his arrest is a case of intimidation and implicated and specifically named the NPA and SAPS leadership having a hand to play in this, specifically also mentioning yesterday the police minister, Magistrate. To what extent will this be as a possible flaw or showcase a possible flaw in the policing process and, in fact, in the prosecutorial process?
Well, he who avers or he who alleges must prove. Quite frankly, the allegations that are made by Advocate Teffo, to the extent that he knows that his arrest is orchestrated by the higher echelons of the police administration, leaves much to be desired, but places him with a burden of proof. But of course, in South Africa, me and you knows that it's difficult to prove such levels of corruption and manipulation, especially when you're working against the tide, and tide being the police force, the prosecution authority who use the might of the law to frustrate you. We know that they've got all the capabilities, the human force, and the legal instrument to frustrate that burden of proof. But what is important for South Africans to note is that what happened yesterday in court has got an element or the propensity of plunging the credibility of the police into further disrepute. You would recall, my sister, that the South African Police Service is the most sued department across all government departments for unlawful, wrongful arrest and detentions. It leads billions of rands in unlawful and wrongful assault and detention settlement cost year in, year out. And already police brutality and abuse is reported across the spectrum in the various aspects of our country, to the extent that it's difficult for people to have trust, legitimate trust and confidence in the police system. So for Advocate Teffo's mishandling in the manner that he was, and this is notwithstanding the fact that there is a valid warrant of arrest, but one want to argue that from a collegiality point of view, from a professionalism point of view, especially if this is someone whose address is known, whose chambers is known, it was quite extremely unwarranted to have handled him in the manner that we have done. But here's the thing. There is a probable cause that the police wanted to send a message that if you become a voice and if you become a sentiment and a strong articulation against the police, this is a might of the law, which is unlawful, by the way, that you made force. And this has got the resultant consequences of sending a very panicking message to the citizens of our country that the police are draconian. The police are above the law. The police cannot be touched. The police cannot be challenged. And this doesn't augur well for our constitutional democracy.
Absolutely. Thabo, thank you so much for your time this afternoon. Really do appreciate it.
My pleasure.
That, of course, is legal and transformation practitioner Thabo Masombuka, of course, weighing in on yesterday's arrest of Advocate Teffo, saying that, of course, there is probably, legal bindings that we saw Advocate Teffo being arrested, but the manner in which the police conducted themselves yesterday is definitely questionable.